Many clients contact my office about bail in domestic violence cases in New Jersey. Recently, the laws changed in New Jersey, and now any domestic violence offense requires that you are processed on a warrant and go to the jail, okay? This means that in the old days, certain minor offenses, misdemeanor level offenses, you could be released on a summons, meaning you would just get paperwork, you would be processed, fingerprinted, take a photo, mugshot, and you would be released with a court date. That's known as a summons. But in New Jersey now, any domestic violence offense requires a mandatory arrest and that the arrest be placed on a warrant and you go to the county jail. This has serious implications because a person arrested for even a misdemeanor level simple assault is going to the county jail. Their bail will be reviewed within 24 to 48 hours of that arrest, okay? So typically you get arrested for simple assault, you go to the jail, the next day there will be a bail review, usually around lunchtime. The judge will review your bail. The prosecutor's office at that point will make a determination on what they want to do. They essentially have two options. They will release you with a court date and you will be released with no conditions, just that you appear in court and that you have no contact with the victim, or they will move for detention. If they move for detention, this means that they think it's a serious offense and that they are asking the judge to hold you while the case is going on. If they move for detention, a detention hearing will typically be scheduled within 5 days of that bail review. So this means that the person, the defendant, will be sitting in jail for at least 1 day for the bail review and then another 5 days for the detention hearing. Your attorney can do nothing at the first appearance bail review. The defense does not get to argue. The judge, honestly, does not even get to weigh in on the determination. It is totally the prerogative of the prosecutor's office at that bail review. Will they release you or are they applying for detention? At the detention hearing 5 days later, that's when your attorney gets to argue for your release, submit character letters, proof of employment. The victim, the alleged victim, if they want to be heard and they want the person released or if they want them to remain in jail, that person could also get on the Zoom call or in person for the detention hearing to determine whether or not the person will be released. At the detention hearing, then, the judge will decide if the person will be remanded, remain incarcerated for the duration of the case, or if they will be released with certain conditions. These conditions can include reporting by phone, reporting in person to probation, alcohol assessments, mental health assessments, house arrest with a bracelet, things of that nature. And like I said earlier, no contact with the victim. Almost all domestic violence cases have a no contact order as part of the bail release unless the victim gets on the detention hearing or the first appearance call and tries to have the judge not impose the no contact order. Otherwise, it'll typically be imposed. If you need assistance with a domestic violence case in New Jersey, contact my office anytime for a free consultation.